Welcome everyone to this Connecticut CASA session on immigration law and child protection, an attorney's perspective on key issues. We're delighted to be joined by attorney Hollis DeAbreu Davis, and attorney Hollis received her law degree from Florida A&M College of Law and her undergraduate degree in political science from the University at Buffalo. She's currently the deputy supervising attorney at the Volunteer Lawyers Project in Western New York. Prior to joining that organization, she worked in private practice focused on immigration defense in Western New York. She's worked in many areas of the law throughout her legal career, including clerking in criminal state court in Connecticut and worked as an attorney for the Federal Small Business Administration in DC. So, attorney Hollis DeAbreu Davis, thank you very much for joining us today. We understand that is through your connection to two of our board members, Jody Oshana, who's with us, and I expect that another attorney, Aisha Roche, will also join us at some point. So welcome, and we expect there will be ample opportunity for questions and discussion during this session.
Thank you. Thank you so much. I always want to start anything like this with just a little bit of background about myself and why I chose to do immigration law. I came to the United States when I was 4 years old and I was undocumented. So all I knew at that point was I was living in the United States. I did not know that I did not have status until I was around 12 years old. At that point, we actually had to self-deport back to Guyana, where I'm from, Guyana, South America. And our application was actually denied initially. And we had to apply for a waiver. And the waiver was based on my United States citizen sister and my United States citizen stepfather. So that's how I was able to come back to the United States. And that's why I do immigration law. It's near to my heart, and that's always been my focus. Right now, as you said, I work for the Volunteer Lawyers Project in Western New York, and we handle removal defense. So at this point, all my clients are detained or have been detained in the Batavia Federal Detention Facility, either coming from the southern border or trying to cross over into the Canadian border and have been detained by ICE. So that's just a little bit of background of what I do and why I do it. So if we can start the slides, please. And I really try to, it's a lot of different topics, and it may seem like a hodgepodge of different topics, but I really tried to focus on specifically what you guys would have questions about, I think. And feel free to ask questions during the presentation. I don't like just talking into the screen. So if you have any questions, feel free to ask during the presentation. So what I wanted to cover was path to status, the types of different applications that can be filed, what a VAWA petition is, and if any questions that you may have. So we asked, well, what exactly is immigration law? So immigration law deals with any non-citizen, how long you are in the United States, if you can enter the United States, for what purpose you can enter the United States, how long you can remain, and if you can be removed from the United States. Next slide. Which brings us to the topic of status. I think for all attorneys, it's important whether you deal with criminal clients or whether you deal with children in particular, it's important to know what particular status your client has to determine what relief or what benefits that they can receive within the United States. So the first thing that you should ask your client is what's your immigration status? And actually, sometimes they don't know. Minors, sometimes they don't know what their immigration status, like myself, I didn't know. I just knew that I was here in the United States. Under what status, I did not know. So the first status that someone can be here under is a lawful permanent resident. That is sometimes referred to as a green card holder. So someone comes to the United States with a green card, or they can either adjust to green card status within the United States. They can remain indefinitely, and they receive benefits just as a citizen. The only thing, a lawful permanent resident can be removed from the United States. And when I say removed, that's the term for deported. It's just called removal. The other types of status is you can be an asylee and or a refugee, and I will talk about the differences between those two terms. Another category is a non-immigrant, meaning that you're here in the United States on a temporary basis. You've entered the United States as a tourist, as a student. You're here maybe on an employment visa. You're here doing religious work, or you are entering the United States as a fiance of a United States citizen. And again, those visa statuses are only here for a temporary amount of time. If you do not depart after that time, you can be placed into removal proceedings. Other categories are TPS, and those are actually designated to certain countries, and it is determined on when you entered the United States, what country you are from, and whether or not you have committed a crime. So certain crimes make you ineligible for temporary protective status. The other status is DACA, and I'll talk about that in detail. Right now, there is an injunction, so that means that you're not able to file any new DACA applications. So that is not a benefit that if you do not have it, you can pursue. I also want to talk about DACA. It's not a status, unfortunately, but it does come into play when people discuss DACA. That's the deferral action for parents of Americans. That is also under an injunction and currently not any relief that someone is able to avail themselves of. But I did want to put it on there just so that, you know, if someone refers to that, it's not a status, unfortunately, that they can actually pursue. And then the other category is undocumented. Obviously, someone here in the United States that do not have any legal authorization to be in the United States. And we'll talk about that soon. So as I said before, if someone is a lawful permanent resident, they have authorization to remain in the United States indefinitely. They may sponsor a spouse or an unmarried son or daughter. They can travel in and out of the United States, and they can actually naturalize. They can adjust to United States citizens within 5 years or 3 years if you are married to a United States citizen. And you can be deported if you commit a criminal offense. I wanted to talk about I know a lot of people say that, well, why don't people come here legally? Well, I looked at the bulletin board this morning, and it's a bulletin board regarding the charge. If you are a lawful permanent resident, and let's say you are from Mexico, and you would like your spouse to enter the United States, there is a 22-year waiting list currently if you are a lawful permanent resident to bring your spouse to the United States. Yes, that can change if you become a citizen, then you get automatic preference and that person automatically comes to the United States. But I just wanted to just give you an example of the timeline some of these countries take to come to the United States. Next slide, please. So next I wanted to talk about an asylee and a refugee. Both asylee and refugees are here because of protection for individuals who are persecuted or fear persecution in their home country. They receive a work authorization, and after 1 year, they can adjust to a green card holder. The difference between an asylee and a refugee is an asylee comes to the United States. So they're at the border, they're seeking asylee status. They're seeking protection from the United States at the United States border, or they're in the United States and they're seeking asylee status. A refugee gains refugee status outside of the United States. So they apply for refugee status outside of the United States, and they actually come to the US as a refugee. So they already have their paperwork once they enter the United States, and they receive the benefits as a refugee upon entering. That is important because the status is an asylee and a refugee. That means that they're not technically admitted into the United States. They can only be admitted into the United States after 1 year when they apply for a green card. So once they are here for 1 year as an asylee or a refugee, then they can get a green card. And after the green card, that's the time that it stops for you to become a citizen, that you can apply for citizenship after the 5 years or 3 years.
I'd like to ask a question, if I might.
Yeah.
What constitutes persecution?
That is a difficult question. Well, not so difficult. Persecution is a threat to your race, religion, particular social group, nationality. So if you've been harmed or fear future harm in the country of your origin. Some examples of persecution are physical violence, threats, imprisonment, things like that. Any other questions? So, and I'm glad you asked. So sometimes I have to have really serious conversations with clients regarding what their actual fear is. So for example, a lot of clients that come from Haiti, they have human rights issues going on in Haiti. There's a humanitarian crisis in Haiti. However, that doesn't necessarily qualify you for asylum status. It has to be a specific threat to you. Corruption is not a category in which you can seek asylum for. That it wouldn't qualify you. And at this point, a lot of younger clients come in or enter the United States because they're running from gang recruitment, meaning in their country that they're actively being recruited to join gangs. Unfortunately, in this jurisdiction in Western New York, that has not been a successful claim to grant asylum status, unfortunately.
Not to belabor this, but I real quickly, some years ago, I was in the United States Peace Corps in Uganda, and President Museveni, he issued like death threats against people who were gay and lesbian. And I know that there were some people who were seeking refuge or asylum in the United States and were denied. And so I was trying to put what you just covered here into that particular context. And it sounds like they don't qualify for asylum or refugee status because they don't fall under the 4 conditions that you listed.
Well, for example, if you're claiming persecution based on being homosexual, that would be a particular social group. And this particular social group would have to be articulated in such a way that it's cognizable, meaning that it is distinct to you. So the persecution, you have to show that you yourself would be persecuted if you return to your home country, not a general fear of persecution or a general threat. It has to be specific to you. But things like persecution based on homosexuality, that is a claim that I have pursued in immigration court. The issue comes with, unfortunately, in immigration court, you have to have evidence. You have to show that, yes, that unfortunately, you really do have to show that you are part of your particular social group. Letters from people that you've been in a relationship. It has to be known through the community, meaning that people would have to know that you are a homosexual, and things that you don't think you would have to show in other courts, you do have to show in immigration court. Or I talk in the concept of immigration court. You don't have to be in immigration court to file for asylum. You can do it affirmatively, meaning you can be in the United States and you can file for asylum through the USCIS, United States Citizen and Immigration Department. But you have to file it. If you're in the United States, you have 1 year to file for asylum. After that, you do not qualify for asylum after 1 year. You must file 1 year after you've entered the United States. If you do not file after that 1 year, you can file a fear-based claim, but the standard is heightened. You'd have to go for withholding of removal, or you have to go for protection under the Convention Against Torture. Protection under the Convention Against Torture means that if you go back to your home country, you will be tortured by the government or someone, if the government allows someone to torture you. So the steps are higher if you don't file within that 1 year.
Thank you.
You're welcome. So which brings me to the types of different applications. And I know DACA is particularly for what you guys do, maybe something of interest for you. But deferred action for childhood arrival, it's an executive order that was created by the prior administration in 2012. So you have to have been in the US under the age of 31 as of June 15th, 2012. And you had to enter the United States before you're 16 years old. You have to be physically present in the United States and have no lawful status. You have to be enrolled in school or graduated or obtained certificate of completion. What people don't know about DACA is you have to have a stellar background. You have to be in school or graduated school. You can have no criminal history, no criminal offenses against you, and you have to maintain that throughout the pendency or throughout their grant of DACA status, or that status can be withdrawn, and you can be placed into removal proceedings or deportation proceedings and have a threat to return to your home country. When you file a DACA application, you have to put down every single family member that you live with. That means that exposes the entire house to immigration proceedings, even if they're documented or undocumented. So it is something to think about when someone is filing for this particular status. Unfortunately, at this point, there is an injunction in place, meaning that there cannot be any new DACA applications. This can't be a relief, but if you did have DACA, you can maintain your DACA and renew your employment authorization card. So it's still being litigated in the court, and hopefully with the new administration, we'll come to some kind of understanding or agreement regarding future DACA recipients, because it is a benefit. These minors have come to the United States not on their own. They'd be brought by their parents, and now they're here without status and no path to any citizenship. The other thing is, if you, it depends on your state. You're not able to get any benefits as far as financial benefits for school if you don't have any status. So the hope is that this is an application that at some point will be available, but it's not at this point. Next slide, please. The other thing that to keep in mind, and again, I don't know what capacity you represent minors, but it's something to keep in mind. If your minor has parents that are United States citizen, they can get derivative status from their parents. It depends on what year they were born. There's a specific chart whether or not you need both parents as citizens to get derivative status, or if you just need one parent to get derivative status for citizenship. This is helpful a lot of times. I have a lot of younger clients that are put into immigration proceedings, and that is the first thing I look for. Can we get derivative status from one of your parents so that we can get you out of removal proceedings? The other things that you can get derivative status from is if your parents or parent has an asylum grant, then you would be able to get that benefit under their grant, as long as you are in the United States. The other thing is the benefit from a lawful permanent resident. Your parents can sponsor you to the United States to come in as a green card holder. And this is my favorite quote: "No one puts their children in a boat unless the water is safer than the land." So you really have to think about it. They're not just getting on a plane and the kids, they're not just putting their kids on a plane and entering the United States. They're crossing over several different countries to get to the United States. They're literally crossing the Rio to enter the United States. So you really have to think about how bad is it in your home country that you would go through that process with your children to come to the United States. But that's just like I said, a lot of my clients have fled gang recruitment, which is a really big problem currently in Central America, El Salvador, Guatemala, Honduras. Gang recruitment is the #1 reason why younger clients come to the United States. The other thing, and I'm sorry, it's just a hodgepodge of topics. I just really wanted to make sure that I covered. But if a minor enters the United States, a possibility that they can file is what's called a special immigrant juvenile status application, also known as SIJs. So it's a benefit available to children who are the victims of abuse, abandonment, or neglect. It gives them a path to lawful permanent resident status. It's under the INA section 101 to 27J. And this is dependent on a state order. You have to have an order from the state court along with your application in order to receive a grant of SIJs. You have to show that the reunification between one or both parents is unavailable due to abuse, abandonment, or whatever your state law deems. So you can have one parent in the United States and one parent in your home country, and you can come to the United States as a minor, and that parent in the United States can get guardianship of you in state court, and you can still get a grant of SIJs. It just has to be an abandonment of one parent. So this is really helpful to minors that enter the United States and either are coming to meet a family member or even their one parent in the United States. Obviously, you have to show that it's in the best interest of the child not to return to the home country. And like I said, there must be an order from the state court. So the application that you would file with immigration is called the I-360. However, with that I-360, you must have the state court order. So how this plays out in reality is, let's say a minor comes to the United States, they cross over into the United States, and they are going to meet a family member or the other parent. That other parent would get a grant in the state court for guardianship. Once they get that state grant for guardianship, then they would file their I-360 along with that order from the state court. If they are in removal proceedings, and this does happen sometimes, minors cross over into the United States and they're put into removal proceedings and they have an active removal or deportation case. If you can show that you're going to file an application for SIJ, you can ask the court 2 things. You can ask them to administratively close your immigration file, or you can ask that they put it on what's called the status docket, meaning that it's just going to be held on this cloud docket until you get your grant so that they can close the file. If you are placed on the if you receive an administrative closure, the issue is that your case can be reopened. You can be reopened for any reason, such as you committed an offense and you would be placed back into removal proceedings. But it doesn't just stop at the I-360. So you get a grant of your I-360. After 1 year, you can then file what's called a 485, which is an adjustment of status to have your green card. So the I-360 is not a status, but you have the path to get a green card. Next slide. The other type of applications I want to go over are what's called a T visa. So a T visa is a victim of trafficking. It could be sex trafficking or labor trafficking. So if a minor is brought into the United States to do any of those things, you can actually apply for those applications with the immigration department. Next slide, please. The other application is called a U visa. Those are the victim of a crime. Some qualifying crimes are abduction, kidnapping, rape, sexual assault. If you are the victim of a crime within the United States, this is an actual visa application that you can file for status within the United States. You do have to show that you were helpful with the police department. So part of the application is actually getting a signed I-918 with the law enforcement. So you actually have to send that application to law enforcement, and they have to sign off on it saying like, yes, you were the victim of this crime. Yes, this person was helpful. So along with that, you would be able to file for a U visa. Currently, however, it takes at least at this point 5 years to get a grant of a U visa. So your application would just be waiting for a grant for a U visa. So a T visa and a U visa aren't helpful to you if you are in removal proceedings, because the judge cannot adjudicate a T visa or a U visa. Only the immigration USCIS can adjudicate that. So the judge is not going to hold your case if you're detained for a grant of these applications. But it is helpful if you are on the outside, and if your client says, you know, I've been the victim of a crime, that is maybe something that you can, hey, maybe this person can get some kind of status through these applications. Next, I wanted to talk about VAWA, which is the Violence Against Women's Act. Obviously, you do not have to be a woman to avail yourself of this application. You could be a man, you can be a child to actually apply for this application. So if you can get this application if you are the victim and your abuser is a lawful permanent resident or a citizen of the United States. You can self-petition for these status within the United States. And if you're granted, you receive work authorization, you receive access to public benefits, and you are in control of the application, and the application is kept confidential. Next slide, please. So who is eligible? If you are unmarried and under 21, so it's not even 18. So if you're unmarried and under 21, you can actually file for this application. And if your batterer is like I said, a lawful permanent resident or a United States citizen, and you've lived with them. So you have to live with them, and if you're a person of good moral character. So some of the documentation for this application, you really should seek an immigration attorney if you are filing this petition, because a lot of it has to do with documentation. The difficulty is if you are in an abusive situation, you may not call the police and have documentation of police reports. You may not go to a doctor because you have bruises. You may not seek therapists because you are in fear and under this domestic violence situation. So a lot of the applications have to do with documentation, affidavits, talking to friends, affidavit from friends, secondary evidence to help prove your case, because a lot of these, this is going before an immigration officer that just has your paperwork in front of them. So the more evidence to provide with your application, the better. It's under 36 USC section 12291 B2, and it's confidential. Is obviously to ensure the safety of whoever is filing the application. And like I said, it's kept confidential so that it protects you when you file it. Next slide. So it protects you in case, and let me clarify, we're talking about people in the United States without documentation. So a lot of the other issue is if you're filing for a relief, you are not documented, and that does open you up to immigration proceedings because you're undocumented, and a lot of times people do not want to go forward. So the confidentiality protects the person that's filing the application. So it protects you from having enforcement action taken against you at a shelter, a crisis center, victim services, or community-based organizations. I have clients that have been undocumented and picked up at their parole, that have been picked up at when they're leaving court, because at that point, immigration knows that this person is undocumented and they are going to their probation or they're going to court, so they pick them up. This protects victims from things like that happening to them. because as I said, people may be reluctant to file these applications if they know that it opens them up to immigration proceedings because they are undocumented. The filing process is similar to that of STIGs. You need to start off with an I-360 and the supporting documents. The processing time is 33 to 30 months to actually file or actually get an answer to your application. But if you do get it, you receive, like I said, all the public benefits that certain public benefits, and that is determined by your state. It's valid for 160 days and renewable. If you're approved, you can get a work permit, like I said, and you are also available to adjust to a green card holder at some point.